Morning. I'm going to focus on just the facets of the American Invents Act that force you as patent attorneys, you as inventors, you as engineers to change the way you've done things for the last 130 years. It's just crucial to understand that so many of the assumptions of the old law that are just embedded in the way you do your day-to-day engineering and your day-to-day lawyering have changed. It's not just it's not like a tax change here and there that change the way you structure your tax return. It's a fundamentally different way of running businesses and of advising clients. The two things that I'm going to focus on are the change to Section 102, the basic definition of what is prior art. If you're an engineer, it's that definition, the legal definition of if you come up with an invention today, you file for a patent application a month from now, but somebody else is working in the same field at about the same time, and you have two kind of colliding inventions, how much first do you have to be ahead of the other people? The main driving force in the bill from the very beginning with the main Intellectual Property Law Association was changing from first to invent to first to file. That is, when you have two people who walk into the patent office at roughly the same time, within a year or so of each other, two people file patent applications and both try to patent identically the same invention. You have to choose between one or the other. You can't give the same patent to both, so you have to choose between one or the other. Which one do you choose? Our old system has been, you look and see who started working on it first. The new system is, you look at the timestamp on the patent application. Who walked into the patent office first? All right, as I described it to you, the fact patterns in which this arises are very narrow. There are under 100 of these events a year. Yeah, it's nice to simplify it, but it doesn't matter because it's such a rare event. That was the big thing in all of the sales pitch, and it doesn't matter. What does matter is that redefinition of prior art, the redefinition of novelty, what we call Section 102. That changes everything. As Keith started to discuss, and as I'm going to discuss in a little more detail, the old law gave you a grace period, a certain amount of time to think, time to get your invention right before the patent lawyers come in, start charging you a lot of money, and more importantly, taking a lot of your inventor's time, and you start filing patent applications. The new statute takes away that time to think. And this will, where the other one affected 200 patent applications a year, this is about 100,000 inventions a year. Inventions that are going to have to, you're going to have to change the way you do things. So what were the intentional changes? To slightly oversimplify, under the old system, you started working. The fact that you were working on your invention was legally relevant. You started driving stakes in the ground from the day you start mixing up whatever, from the day you start programming. Under the new system, the only legally relevant event in your patent filing rights are the day that you lick the stamp, put it on the front of the envelope, and drop a patent application in the mail, or electronically file it. Prior art is anything that anybody else does anywhere in the world before your filing date, with one very narrow exception, well, with two very narrow exceptions. First of all, if you make a disclosure of the invention, you have a year to file your patent application, as long as no one else does anything. Under the old system, the fact that you were working on your invention was protection against not rock solid protection, but the practical reality as a business matter is that it was almost always good enough protection against what everybody else in the world was doing. Under the new system, the only event that protects you against magazine articles, trade shows, publications, patent applications that are kind of in the field but a different invention. Under the new system, the only step you can take to protect yourself against all of that other stuff is to file a patent application. There's also a small exception for commonly owned stuff. If you are a big multinational company and you've got multiple people working on related stuff all around the world, under the old system, you had to manage that. Under the new system, it's the self-collisions are the self-collisions don't create prior art against yourself, which of course is terrific if you're a great big multinational company and you've got 20 labs around the world. To a startup, doesn't matter a whit, right? The other thing that is going to play into this is the prior user rights defense. It's been there for a decade, but only in the context of business methods. Now, the way prior user rights work is if you've been working on an invention, started commercializing it, but kept it secret for a year, somebody else gets a patent on it, but you've been using it commercially, and they come and sue you, you have what's called a prior user right defense. If you were making commercial use of it, even if you didn't patent it, even if it was secret. And so that's going to fall into the trade secret bin. I'm going to leave for Professor Mossoff. So one of the things as lawyers, we have had the great luxury of an incredibly stable law for the last 110 years, 130 years, depending on how you count. We can advise clients with great certainty what the law is, what your rights are. This new statute, unfortunately, introduces acres of ambiguity. And that's going to affect everything that you advise a client on. You will, in large part, have to tell clients, look, I can tell you that here's the safe end of the spectrum, but here's the other end of the spectrum, and the law may come out this way, and today I can't tell you which way the law will sort out. We can take the safe course, but if there's enough profit in pursuing something in between those two, in between the ambiguity, it may be worth taking the risk. Lawyers are not comfortable advising clients on risky courses, especially patent lawyers, because we haven't had to. Right? We've had this incredibly stable law. You could look up Federal Circuit law on every point and advise your client with great certainty and great precision. That's not there anymore. Professor Wegner, many of you get his emails every day. One of them says, drafting ambiguities permeate the statute and more are being seen as the hallmark of this legislation. All too often, the apparent intention of the legislature is countered by statutory wording that's inconsistent with that apparent intention. Now, I'm going to just fly through the next 10 or 15 slides because Rick Neifeld is going to do the hand-to-hand combat here, but I just want to get some sense for what they are. We just talked about the first point here. How do you resolve ambiguities? Right? Normally, there are three places you can go. You can go to the legislature and have them pass further legislation. You can go to the courts and get them resolved. But both of those take decades, as we'll see in a moment. In other areas of the law where an agency has substantive rulemaking authority, the agency can promulgate regulations to resolve the ambiguity. And indeed, several people in this bill said, yeah, we know that this bill's ambiguous, but the Patent Office will be able to promulgate regulations. I'm flabbergasted. We just had a major litigation about that only 5 years ago, the one that Keith mentioned. The Patent Office doesn't have the authority to resolve ambiguities. And so we're going to be stuck with it. Here's a graph that shows how much ambiguity there will be and how long it will take. Here we go of the history of the patent law from 1830 to 2010. There were two prior major statutory changes in 1839 and in 1870. And in that 180 years, there were 17 trips to the United States Supreme Court on Section 102 or its predecessors. Of those 17 cases, 2/3 of them fall between 1870 and 1895. What does that tell you? That tells you that statutory changes, even fairly innocuous ones, 1870 was intended to be a codification of previous law, create ambiguity. And the only way you can resolve ambiguity in our legal system is to go to the Supreme Court. And that took 25 years. We've been living, it's kind of a little bit like global warming. We've been living in a calm world for the last millennium. Well, we as patent lawyers have been living in this stable range here for 100 years. Well, we are entering this period. And you're going to have that kind of ambiguity for decades. I'm just going to fly through these. A new statutory term is this one, otherwise available. What does available mean? For the last 140 years, to create prior art, you've had to push information out. You've had to have a public sale, a printed publication, or a public use where you intentionally go out for something. Suppose you have a more or less unintentional available, an FTP site that isn't locked down type. It's available to the public. Here's the one that I'm going to talk about several times during the talk, so I'm going to give a little more detail here. Do the terms on sale and public use mean the same thing that they did for the last 140 years? There's legislative history on both sides of this. One school of thought is that we say public use, on sale, or otherwise available to the public. I've added, it's just a catch-all. It's just an additional catch-all, no change to public use or on sale. The other reading of this phrase, which has proponents, there's legislative history, says, well, or otherwise means that available to the public is a new constraint on public use and on sale. A private public use, a private on sale, which in some circumstances can be a bar under current law, are no longer a bar under the new law because we want prior art to be defined by what's available to the public. Well, you have two ambiguities. First of all, does or mean or does or mean and? There's legislative history on both sides of that, sometimes from the same speaker, sometimes in two sentences right next to each other. Nobody knows. And if it comes out that or means and, what does available to the public mean? Holy smokes. Metallizing engineering. You use a process or a machine in secret to produce a product that you sell. Everybody's known since 1829 that that's a bar. There was discussion early on that we wanted to repeal metallizing engineering. It's not in this legislative language, it's not in the legislative history, but commentators are saying, oh yeah, we intended to repeal metallizing engineering. Did we repeal metallizing engineering? Who knows? We talked about the grace period requires a disclosure, but the word disclosure isn't defined. There's legislative history that says we intend symmetry. There's legislative history that says, no, we intend disclosure to be broader than prior art. What does it mean? Nobody knows. Experimental use. Does that survive? Nobody knows. And then what's striking is, I have friends on some of the committees, they said, when we were discussing this committee, everybody read it. Everybody in the room knew that it had two different meanings. Some people passionately wanted language that meant this. Some people passionately wanted language that meant that. The only thing everybody in the room could agree on was this wording. It's like a treaty where you have countries where you deliberately come up with fudging language that people can sign off on. In a treaty, the intent, everybody knows what's going on here is you have two countries that know they need a treaty, and neither intends to perform at the middle of the treaty. They both intend to fudge. Well, that's fine in a treaty. It's not fine in a patent statute, but that's what we've got. And that's what you as attorneys and as business people, that's the ambiguity you're going to have to deal with. But it's not just the language in the statute that's ambiguous. There are a number of things that are going to make litigation much more complex. For 140 years, on sale and public use has been in this country. That is, when you need to take a deposition of somebody, what did you do in this machine? How did it work? When did you start doing it? It's in this country. That deponent is not absolutely every time, but overwhelmingly in this country. Well, now prior art is worldwide. Now, lots of other countries have worldwide prior art statutes, but they don't have US discovery and deposition rules. Those of you that know anything about litigation outside the US, discovery is very narrow. Depositions are very rare. Worldwide prior art works fine in a world like that. For the first time, we're going to combine worldwide prior art with US discovery rules. Brush up on your Hague Convention deposition practice. That or otherwise thing. The intent there, according to the proponents of or otherwise, meaning and, is that when somebody sells something, the question will be, can you reverse engineer it? Does the article sold teach how to make the invention? For the last 140 years, we've said it doesn't matter. If you're selling it, the public has a device they can use. What do we care whether the device teaches how to make the invention? Well, the proponents of that reading of the statute say, well, but if you can't reverse engineer it, then the invention isn't available to the public. Well, now we're going to have a battle of experts on these on sale and public use cases. One expert saying, yeah, I bought a golf ball. I can easily figure out how to make that rubber composition. And the other expert is going to say, oh, no, 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 I couldn't do that. I couldn't do that. Can too, cannot. Can too, cannot. And it'll make it impossible to settle these cases because until you have a judge decide between these two conflicting the testimony of these two experts, you can't settle the case. You don't know. Derivation. We've had very few derivation cases under 102F, thank you, for decades because it's hard to resolve derivation issues. And you can almost always resolve the case on some other ground. Well, lots of those other grounds are gone, and the scope of derivation has increased. And there are lovely British cases about derivation is this terribly difficult issue. Well, we're going to have more of them. And then some of the substantive issues, the Congress forgot to amend the procedural statute to provide for a forum and for the rules to resolve the substantive issues that they created. It's in my papers from 2 or 3 years before they passed the statute. I don't know how they missed it. So let's start going through what does this mean commercially. As I said, under the 52 Act and going back to at least 1870, you've had time to think, time to talk, time to find outside investors, time to find a subcontractor who will make that little difficult part for you. Time to negotiate financing, time to find marketing partners, time to do all that stuff, to build a business before you have to call the patent lawyers. Time to figure out, is this a good invention or is it a dud? Should I give up? When you have an employee that leaves and goes to work for a competitor, no big deal, because we had conception and diligence we were working on. I don't care what information that departing employee takes with them. My patent rights, I've been putting those stakes in the ground. I'm set. That's gone. The only thing that matters now is filing a patent application. Finally realized what it is, the second bullet here. Under the old grace period, it wasn't bulletproof for you, but it was good enough that as a commercial, practical reality, commensurate with all the other risks a business takes, you could rely on that grace period to delay your filing until you know what the right thing to do is. The new grace period is like the morning after pill. You would never plan your course of business intending to rely on the morning after pill as your primary way of dealing with risk, right? The morning after pill is something you use when you had an accident. The new grace period is there, and it's there if you had an accident. You may be able to recover, but you can't rely on it in a prospective and ex ante way, the way you did under the old grace period. And the reason is that under the old statute, almost all of the facts that you needed to establish your grace period were facts that you created and facts under your control and facts that you had time to find out about. You had a year to find out about them. Under the new statute, all of the facts that matter are things that other people do, and by the time you find out about them, it was yesterday and it's too late. So under the old statute, the typical things that a business does to reduce risk worked. Under the new statute, they don't. The key one that makes a big difference is you come up with an invention, you sell a widget today, for test marketing purposes. Somebody else is working on kind of the same field, they have kind of the same thing, kind of the same, kind of different. They test one, disclose it, do something. Under the old statute, you were first. You're still protected. You have a full right to a full generic claim. Under the new statute, you've got these two inventions that are near each other. That new one is prior art to you. You can still get a claim because you have a grace period, but it's going to be that little tiny claim around precisely what you sold. You probably can't get a generic claim that covers both of you, as you could under the old statute. And the Patent Office is taking that reading in the first to file regulations that were published a little over 2 months ago. And in particular, if you advise startups, venture capital investors, this is pretty crucial. Under the old statute, in Boston we have these, and in Silicon Valley, you have a big auditorium, and all of the investors come in, the venture capitalists come in at one end, and the inventors come in at the other end, and you have presentations and you talk, and guess what? The fact that you are talking shows that you had the invention under conception and that you were diligent on it. These conceptions were one of the stakes that you could drive in the ground to perfect your grace period. Now, conception, diligence doesn't matter. It's legally irrelevant. And the problem is, anytime you talk with an outsider, that information can start to flow. And if it starts to flow and goes somewhere that you can't control it anymore, you now have a bar against yourself. If you can prove that the information came from you, the derivation law says That's not prior art against you, but that's that procedural thing. The procedural law wasn't updated to give you the right to find out how did that information get out there. Can I trace that information back to me? And we can see what the result is, because Europe, with a statute much like what we have now, has essentially no venture capital industry. Canada used to. Canada in 1988 adopted a statute very much like the new AIA. Canada now, the Canadian government published a report in a few years. Venture capital has fled the Canadian market. That report doesn't correlate those two events. It's hard for me to see how they couldn't be correlated. What's another big factor? The field of prior art has gotten much bigger. In Europe, where you have to race to the patent office, of initial filings in Europe, this is filings where you didn't come in through the PCT, it's not a second filing based on a US filing. Over 60% of applications get abandoned by the time of a first office action. In the US, it's been about 22% of first filings. There's the difference between patents that help build businesses and patents that are just expenses. Here's Canadian data, a couple of folks at UPenn Law School. In Canada, here's where they adopted the statute. Here's where it went into effect. Here's the proportion of applications filed on behalf of individuals as a proxy for small entities. Here's the proportion that were filed by individuals after adoption of the statute. You can see the rather sharp drop right there. And there's the United States above as a control. Sorry you can't see this. This is a chart that just sets up who are the losers. Where, if you were one of these folks or one of these kinds of inventions, you were better off under the 52 Act. If you're one of these kinds of individuals or companies or one of these kinds of inventors, you're better off under the new Act. And just to a rough proxy, if you have a big innovation that's going to change the world that takes time to get the bugs out, you are better off under the old law. If you're a small incremental improvement, say, adding a slow release formulation for a drug, or putting two drugs together in a single pill, then you're better off under the new Act. How much time have I got left? Anybody watching my time? I'm 32 in or 32 left? Okay. So this is about where I wanted to be. One of the key things is that trade secrets become much more valuable, both in terms of preserving your rights and as defensive shields against patents of others. And I'll let Professor Mossoff talk about that. What are a couple things that you as inventors, you as lawyers, have to do to change your practice? Well, if you are a lawyer, probably in-house at a big multinational company, probably you don't have to do very much at all, particularly if you're a big pharma. There's very little that has to change for you. If you're at a big computer company, there's a little bit that has to change. If you represent small companies or startups, there's a lot that has to change. I think I will just, for everyone else, you have to fundamentally redesign your process and recognize that the risks have changed and you have to rebalance them. And just to summarize it, it's file early, file often. And for some companies, that's the way they've done things, and it's fine. For other companies, it's going to be more difficult. Oh. How did that happen? I don't like that. Your R&D planning and process the R&D folks and the patent lawyers just have to work much more closely together. Now, for me, that's fine. I'm in-house. My engineers are on the 3rd floor. I'm on the 3rd floor over in the building next door. Piece of cake. And, it's like being an embedded reporter. It's actually more fun. But if you're outside counsel, this is just going to be difficult. And even for me, I recognize that there's a shift that's going to occur. I used to be, the engineers were driving the car. I was like the kid in the back seat saying, "Hey, Mom, are we there yet? Hey, Mom, are we there yet?" And when they say, "We're there," then I say, "All right, let's get this patent application put together. We only have to do it once. It's finished. I've been keeping notes, but it's time now." Under the new statute, I'm not in the back seat anymore. I'm the driver's ed instructor in the shotgun seat. I've got a brake pedal. Oops, you can't go any faster till I get this patent application filed. And this is going to fundamentally change the relationship between engineers and patent attorneys, which is always a little bit of tension. There's going to be more tension there. If you've got subcontractors where you're sending some of the invention out, particularly if there's a sale between the subcontractor back to you of a component part, you have to look at that. Is that a sale that triggers a bar? Do you have to work? And was there inventive material supplied by that subcontractor? You're going to have to figure out with your client, how do you deal with that file early, file often? Where do you get the budget for it? Where do you get the attorney time to deal with it? You have to deal with the risks of file early, file often. File early means file a thinner patent application. Look past some of the details. There have been a handful of cases in the last few years about what happens when you have an early patent application that doesn't fully support the invention and a later patent application that fully supports the invention but is too late and there was intervening prior art. There have been a handful of those. Those are going to be much more common. That continuation filing, the second filing to fully support the invention, is going to just be at much higher prior art risk because the prior art, there's more of it. It will be crucial to keep your specification and your commercial embodiment tracking each other, because your own commercial embodiment, if it gets too far from your patent specification, it's going to make it really difficult. That's always been true. What's different is that your latitude and time to cure that kind of departure is much shorter now. There's the partial solution is successive provisional applications. As Keith showed on Ron's slide. Oh, in fact, I think I have. Yeah, here we are. Here's another slide from our friend Ron Katz-Nelson, which you can't see, unfortunately. Here's the product design cycle. You conceive an invention, you investigate several alternatives, you pick, this is the winner, these three are losers, drop them, design your system, do your hardware, software, your gate array designs, test it, oops, this is oops, trial and error with an emphasis on error. That's the way real inventions occur, right? Bingo, we have a winner. That's where you file your first patent application. Then you demo it, you put it out for pilot testing, you do your beta testing, you might file a second patent application there. That's the way you did it under the old law. Under the new law, you have to file patent applications on, you either have to or you take the risk of losing something. And this is going to be risk balancing, something patent attorneys have never had to do before and that we're very uncomfortable doing. How much money can you afford to spend? What's the likelihood of those four? You can probably file on 2 of them, right? But not all 4. Early on, you're going to have to, as you go through this iterative trial and error phase, you might have to file several applications there. You've always filed this one. So there's your file early, file often pattern. And that's, for an incremental invention, the path through here is pretty straightforward, right? If you're just taking two drugs and putting them together in a single pill, that's not so tough. And you can file one patent application. But when you're building a computer system with 10, 20, 50 engineers, and what this one does affects what that one does, and there's a cost constraint. Oops, this cycle time is a little too slow. We need to take time out of there. This kind of iterative product design is just going to become very difficult. It's going to be very difficult to keep your file early, file often patent process in place. And you just have to accept it. The filing decisions you make will be of lower quality. You're going to prune out patent applications that end up being valuable inventions. And you're going to file applications that turn out to be worthless. And the applications are going to be lower quality. They're going to be harder to prosecute. You're going to have a far higher abandonment rate. Here's tough. It's the new normal. And the only consolation prize is everyone else, it's the new normal for everyone else too. You still have to keep good development records though. That Inventor notebook that everybody said would go away because we don't have interferences anymore, not quite true. Because you still have that derivation issue, prior user rights, and trade secret issues are going to be far more important than they have in the past. And that Inventor notebook is still going to be the key evidence on those issues. Joint research agreements, when you have, for instance, at my company, Cantor Fitzgerald is like 150 entities on our entity chart. We have to have a joint research agreement between those 150 entities. If you're a university, you have to have your joint research agreement in place with whoever's funding your research, whatever partners you're working with, so that you're not knocking each other's patents out. This is another way of saying the same thing. You probably have to have biweekly or monthly meetings between your patent attorneys and your engineers. For me, in-house, that's not so tough. If you're outside counsel, there are certainly companies that will let you bill them for that. There are others that are just going to be harder, and I don't know how you're going to do that. When a key employee departs, you're going to have the fire drill of talking to everybody that's left. Is there anything we need to file a patent application on? A paper I published about 2 years ago took all of that and added it up, and it's about $1 billion a year in private sector cost. The current private sector cost of the patent system is about $5 billion a year. So, that's a big number. The proponents of the bill said, well, we've got that publication grace period. If you publish a paper, you'll trigger a grace period. But the fact of the matter is that you give up so many rights by doing so. I can't imagine how that would ever be a commercially reasonable thing to do. I'm sure there are situations, but they're going to be few and far between. The other main thing that the proponents of the bill told you was, well, filing a provisional application for a small entity, it's only a $100 filing fee. Well, that was true under the old law, where conception and diligence mattered. Right? If I took the PowerPoint presentations that you're going to give tomorrow, and I just put a provisional application cover sheet on the front of it, I've accomplished something. I've proved conception, I've proved diligence, I've proved all kinds of things that mattered under the old statute, even if that set of PowerPoint slides isn't a full 112A disclosure of the invention. That doesn't matter anymore. A provisional application, remember, the only thing that matters under the new statute is filing a patent application, a full 112A written description, enablement, utility, patent application. And that requires the intervention of an attorney. So the $100 provisional is a thing of the past. You have to prepare your clients that provisionals are just, to have any legally useful effect, are going to cost more. The transition period has a couple of gotchas, and they both involve what happens when you file a thinner patent application and follow it up with a thicker one. And you're just going to have to watch those situations very carefully. Investors, I used to advise a lot of venture capital and angel investors and startup companies in their relations with investors, and just the way you look at a company has changed. Patent attorneys, the relationship between patent attorney and client has changed quite a bit. We've talked about that. But here's one more thing. As a patent attorney, just the opportunities for malpractice have grown immensely. The deadlines are shorter. One really striking thing is that it used to be that when you committed malpractice, it might take a long time for anybody to figure it out, even you, and by that time the statute of limitations has run. Those problems are going to arise much more quickly and be much more visible. And your opportunities to reduce the harm of your own malpractice are really much smaller. And statutory ambiguity. If you advise, you're going to have to be very clear with your clients. Look, the law is ambiguous here. Here's, I'm giving you 2 lines of advice. Because if you advise the client of only one of those options, and you turn out to be wrong, well, you're at least going to face a lawsuit. You may win. You may have acted competently, but being wrong is just not a good way to keep out of court. So that's the end of the talk. Do I have any time left for questions? I'd like to talk about the good news, but I'll take Dan first.
You were talking about disclosures of definition of prior art, where on sale, public use, now anywhere in the world, we're going to have to take depositions. Have you given any thought to the interaction of the time delay or the time period set by U.S. patent statute and depositions in foreign jurisdictions that may not honor our time depositions or time limits? Can you repeat it?
Yeah, the question was, what's the interaction of time deadlines between the foreign deposition practice and our timelines? And I don't think they're going to be terribly important because the new timelines are at pre-filing stage, patent prosecution stage. These foreign depositions are almost all going to occur at the early. Oh, okay. Is that? Oh, there's audio. And the depositions are going to be much later, so that's not a huge problem. Rob? Dan brings up the point that the time to resolve an invalidity challenge in Italy is averaging 25 years. And that at the least puts a cloud on the patent for that period of time. And that's, I have more faith in the U.S. legal system than anything in the Italian government. But yeah, that's going to be a problem. Rob, you had a question?
Well, going back to the point, going back to the point about prior art, going back to the point about prior art now existing worldwide, and the logistical problems of getting this prior art. Also, this prior art could, of course, be used in the new post-grant review process and the new covered business method process. Do you have any ideas or thoughts on whether this is even viable prior art for these contested proceedings as a practical matter?
That was raised in at least a couple of the comment letters, and did they publish? Yeah, the regs published for the final regs published for those, didn't they? Because they, and I don't I didn't review the final comments. What I hope is that the board will say when they are considering a petition for review, look, we have to complete this in a year by statute. And if there's going to be this foreign prior art issue, we can't complete it in a year. So we're going to deny the petition simply on the ground that we can't decide it in our, that's what I hope happens. But I haven't, I know the question was raised in IEEE's comment letter. I haven't reviewed the final Federal Register notice to see if the Patent Office even answered the question. A question?
You online.
This is a question about the grace period, and my question is, are we specifically talking about 131 declarations, or does the diminishing of the grace period have relevance even outside that? And the reason I ask is because I know other prominent attorneys have had huge success sometimes with a declaration that can be like $1 billion win for them, but at the same time I've worked on hundreds and hundreds of applications, and I've never filed a single one, and I've obtained hundreds of patents that I thought were valuable patents. So I've heard skepticism from some attorneys saying, well, the grace period is diminished, but it's not that big of a deal practically. What are your thoughts on that?
The big difference is the ex ante behavior before you file the patent application. The big difference is that under current law, you had that option of filing the 131 declaration. Doesn't happen often, but it's like homeowners insurance, right? When a fire is a 1 in 1,000 house year occurrence, you insure against it and you just live your life. If it's 1870 and a house fire is a once in 10 year occurrence, you live your life very differently. And that's where even though looking at it ex post that way, that doesn't that's looking at the tip of the iceberg.
And one more question is, I know you mentioned that the PTO generally has no substantive rulemaking authority, and that's going to really tie their hand to try to fill in many of the ambiguities in the statute. I also know that they received at least some limited grants of rulemaking authority, for example, with some of the post-grant provisions. But I don't know how much of that is substantive as opposed to procedural. Much of it looks procedural to me. Are there any limited grants that would help them resolve any of this ambiguity, or is it really as bad as you say?
Yeah, I think you point out exactly the statutory language that shows remarkably that there is no substantive rulemaking authority to interpret this. They were, in the post-grant statutes, there are specific grants of substantive rulemaking authority on a handful of limited issues. And that congressional silence, I think, makes it even especially since the Patent Office requested it early in this legislative process. The fact that Congress didn't grant it couldn't make it clearer that the Patent Office has no substantive authority to resolve these ambiguities. They have to give the examiners examining guidelines, right? The examiners have to act for the next 25 years. They have to do something. So yes, the Patent Office can advise examiners, here's the way you're going to here's the law, here's the way you're going to pretend the law is. You're going to examine to this standard. But, we won't know until, many years and court challenges later until what the law really is.
David, are there any more in the room here? Because I've got a series of online questions. And if you are online, I encourage you to send questions during the discussion. I'm trying to be fair and pick out key questions I think might add to your presentation. Jason Taylor had a question for you on how AIA might overall affect restriction practice.
At first level, I don't think it does. But everything ties to everything else sooner or later, and I'm sure that something will come up, but I don't immediately see any interaction.
I can't add to that. Does anyone else in the room want to? I don't have an answer. John Knapp had a question. What benefits could accrue to a group of startups cooperating with joint venture agreements?
The question was, what advantages could accrue to a group of startups who assemble a group of joint research agreements? I assume that they're working on, well, they would, you have the agreement, but then you also have to be within the performance of the agreement. If you have, at most, what a joint research agreement would accomplish in that is that if you're within the umbrella of that joint research agreement, arguably you are not prior art to each other. But courts are going to look past the existence of the paper agreement, I'm sure, and say, were you actually inventing within the performance of that agreement? It's an interesting question to think about, but it seems, courts are not all that happy to defer to a paper that is clearly only a piece of paper.
And I have one more kind of a comment question from Bob Schmidt. David, please comment more on the effect of capital formation for new businesses, kind of the old catch-23 named after predecessor bill S-23. The old angel mantra of you can't raise money until you have a patent. That old conundrum of how are we going to raise the money so that we can pay the patent lawyer, help us rush to the patent office and file.
I'm sorry, you've just really touched a nerve here.
Thank Bob, not me.
Because I've helped startups through this phase, and it's difficult. And the old statute gave you the flexibility to work through things step by step. The new statute creates this circular dependency. You can't go talk to an investor until you've got a patent application filed, and you can't pay a patent lawyer until you've got an investor. It's a circular dependency. It's a catch-23. And I don't know how you solve it. In Europe, it's been that way for decades. And as far as I know, there is a venture capital community in Europe, but it's tiny. The patent lawyers tell their clients, you can't do this till you've got the money, till you've got a patent application filed. And I just plain don't know where this goes. When I gave this talk in Congress, my slide was a picture of my daughter, who's 11 years old. And this bill takes away the opportunities for these new businesses. I'm upset about this. And I don't know what to do about it.
Thanks for the answer. For those of you here, there has been a group of us at IEEE that are trying to put together a symposium with venture capitalists to ask this question. You know, the problem is that a startup company goes out and they show their skirt to 11 companies. And of course, none of them sign an NDA. One of them eventually does. And the one that does, you know, has a board position. But what happens to the other 10? And when they, more importantly, come into your office and they say, okay, patent lawyer, I now have funding. The 11th gave me the money to pay your bill, to bring you on board. And the patent lawyer is stuck in a position where they have to ask, what happened with those other 10 folks? Do you still have rights now that you have the money to protect them? And we've had members in our policy group ask this question. And we're hoping in the next 6 months to have some sort of symposium to get folks together to discuss this problem. And there were 1 or 2 prominent venture capitalists that worked with us in raising questions as AIA was pushed, you know, through Congress. So there are some really strong feelings about this because in a lot of cases it could be a no-go position. And so I think Robert raises a very good question. We don't have an answer to it, but we all ought to know that because as lawyers, these people are going to come into our office if you're in private practice, and they're going to ask you, and you're going to see, wow, can I help them decide whether or not there really is something to protect? And there's a big question mark there, and I'm worried that there's a big constriction there. And as David points out, this just doesn't happen that much in Europe, and some of us believe that maybe that's why it doesn't happen. And maybe that's why it happened here. Maybe we're heading in that direction. So we need to look for these issues in our practices because after March 15th, these folks are going to come into our office and they're going to be asking us these questions, and we should be prepared, 1, to decide do we want to take on this person as a client, 2, how do we give them the best advice to mitigate the situation they're already in, and before this happens, can we give our clients advice so that they don't come into our office on March 16th and tell us this happened. And that's a difficult situation for the clients. That, you know, an engineer just lost their job. It was shipped to Malaysia. And now they have a house and a mortgage, and they get a second, and they get in with a couple of friends, and they borrow some money. And this may be the expert in an antenna technology. They may be the brightest engineers in the world, but they're no longer working for Acme Company. And the question is, how do they get to the point where they can get good legal advice so they can actually get the intellectual property that's necessary for a second or third funding round? And these are really strong fundamental questions. These are the huge areas that are going to change for the IEEE members that are faced with these issues. And the lawyers need to be thinking about how they have to do things differently. Or they're going to come into your office on March 16th, and by then you'll realize there are questions. Is there anything you can do now so that they don't come into your office on March 16th with this conundrum that you can't answer? Or you have to say, sorry, I can't, you know, next time I can help you. Here's what you need to do. I think that's most of the substantive questions. I do have a comment for those online. If you're going to submit a question, if you could please just put, I have a question for the speaker, put a Q and a colon. There's a lot of general comments that I'm not sure are appropriate to pass on that are, some of the people are collaborating on WebEx, so I didn't want to share some things because I wasn't sure they were meant to be public. So if you just put Q and then type a question, when we get done with each speaker, I'll feel free to know it. So I'll be sure to ask the question on your behalf. If you don't want me to use your name, please indicate. Thank you. There is one more question in the audience here.
Thank you. You talked about the pool of false patents increasing. If you're applicant A in your scenario where you file an application and it's going the regular way in the patent office, what do you need to do to protect yourself, or what measures do you need to take against the false patent applicants that are strategically filing and going on the prioritized track and filing non-publication requests?
Yeah, Keith is giving me and that's kind of my answer too. What has been done in the past is if you have some sense for the possibility that may be happening, you kind of have to watch it. And what you do is, as as you see the application progressing, you have to amend your claims to track that so that, so that at least you get the issue on the table earlier rather than later. The AIA limits your right to amend claims to not from the date that the false patent issues, but the date that the claims were amended into the false patent. And that's gonna pinch. I don't know quite how that's gonna work. And I don't know that I haven't looked in the proposed reg. Will you be permitted to contact the examiner of the accelerated application and just raise a red flag? I don't know. That probably would fall within the pre-grant submission area.
They can also file a non-publication request, right? And you won't see that patent until it actually grants.
The question is, could an accelerated exam application be under a non-publication request? And would that affect things? And I don't know the answer.
I don't either. The question I've had is because I follow quite a few of those for startup clients, is being put in a position where you have to forego that because this is a very competitive trade secret. If the startup has a hiccup and they go off to do something else, it's awfully nice that this doesn't become prior art to the extent that it hasn't already been used in a public way. But the secondary and the related issue is, and I've been asked this in presentations, is the due diligence issue. So all of us as lawyers that after March, after this takes effect, our client is buying somebody and we start looking at the portfolio. You've got to immediately realize, wow, here's an accelerated exam patent. How do I opine? What's the value? There's clearly going to be a discount. Until enough time passes, you don't know for sure whether this is a valid patent. So there's going to be a discount applied in doing the valuation on any patent in a portfolio, at least if I see it. And the question is how many others miss that. This is an issue that needs to go on the checklist. It needs to be on the due diligence list.
Do we?
I think that's, two more questions. We're getting close on our time, so let's two more and then we'll be done.
This is just a quick comment because someone I think online mentioned how the AIA affects restriction practice. And I just remembered from your slides, you had a slide which I didn't fully understand about the switch for joint research agreements from 103C to 102A. And I think you asked, does this affect double patenting and how does it? I didn't understand what that slide meant, but it seemed like there might be a connection there.
Thank you. One last question.
My question's on 102. If an engineer submits a paper to a peer-reviewed journal, when would it become prior art, or what's your feeling on that? When it's submitted, when it's sent out to the reviewers, or when it's actually published?
I'm sure that question has arisen in the past, and I suspect that at least on that question, interesting. There we are back to, does or otherwise mean and, or does it mean or? If it means or, and printed publication means what it has always meant, then you can look to old Federal Circuit cases. I'm sure it's come up. If the term printed publication, if that meaning has changed, then we're in the Wild West, and I don't know the answer. It may be that by giving it to the reviewers, particularly the reviewers, they're members of the interested public. Are they under a confidentiality agreement? I guess often they are, sometimes they aren't. I don't know the answer, and it may be very fact specific, and it may turn on whether or otherwise means and or whether it means or. I can't answer that question.